Okay, here's an example of soliciting breach of attorney-client privilege, resulting in disallowing 3 elderly Jewish senior citizens who had lost their brother to cancer years earlier from obtaining an attorney for a trial that was set weeks later. They were never able to get an attorney, so they dismissed without prejudice, and hopefully they'll be able to come back soon. In the meantime, here's this guy right in court admitting that he breached attorney-client privilege. See, it says here quickly, I'm an attorney in good opposition. So the 3 siblings said, we got a lawyer, we need 90 days. The lawyer will take the case, he needs 90 days. Hey, judge, can we get a 90-day extension? So then he objected to their request for 90-day objection. Yeah, he got $57,000 and they got $4,000, but they were supposed to get $90,000 5 years ago plus 10% interest. That's $150,000 to split 3 ways. So he says, I'm an attorney, William John Rogers. I'm an attorney in good standing, license to practice before the court. I am the attorney for Rabbi Yehuda Ferris of Chabad of the East Bay. July 26th, so-and-so filed an ex parte for extension of time. Here's where he's breaching attorney-client privilege. Mr. So-and-so states that attorney Frank Mayo will represent him and his sisters in the continuance of trials granted. Well, on July 27th, on Saturday, I called and spoke to attorney-client privilege, discussed breaching for attorney-client privilege. He told me he had decided he will not be representing anyone in the case. I declare under penalty of perjury that the correct is true. That is illegal, okay? So then they never got the continuance, but in their objection it says, William John Rogers obtained what he knew, this is their objection to his objection, obtained what he knew as attorney-client protected information and violated attorney-client confidentiality, which governs consultations about retention. Will Rogers obtained what he knew as protected information and then lied under oath, attempting to unduly influence this court, and should be disciplined and sanctioned for obtaining, using, and lying, and then lying under oath in this court of law concerning petitioners' protected attorney-client information. He lied to the court, declaring that 81-year-old attorney Frankie Mayo, who was practicing law when Rogers was 12 years old, he said that basically the attorney that he said that he spoke to him and that he wasn't taking the case, but the attorney said he never said that to him. So nevertheless, the judge didn't grant the extension, and so then they couldn't go to trial, so they have to get an extension, and now they're trying to find an attorney. This is corrupt filth from thieves.